Chapter 4, General Doctrine. Section 18, Negotiable Instruments similar to money. As has already been pointed out, the peculiarities which attach to negotiable paper are the growth of time, and were acceded to for the benefit of trade. While all choses in action are now transferable, the negotiable instrument is the only species which carries, by transfer, a clear title and a full measure, and like an instrument under seal, imports a consideration. Negotiable instruments are thus given many of the peculiarities of money, i.e., gold and silver coin and bank bills. Section 19, Bona fide holder. In order to take advantage of the special privileges attached to a negotiable instrument, the holder must have taken it before it was due, and with no notice of any irregularity in the instrument, or of any valid defenses that the maker had to it, and the owner must have parted with something of value in acquiring it. The consideration need not have been money. It may have been property, the granting of credit, or some disadvantage which the holder assumed in acquiring it. Such a holder is a bona fide holder. He is often spoken of as a holder in due course, also, as a bona fide purchaser for value without notice. Section 20, Equities. A makes a certain instrument payable to B, promising to pay him a certain amount of money. That instrument is valid regardless of whether or not it is negotiable by the law merchant. B can recover from A, providing, of course, there has been a consideration, and if B assigns that over to someone else, that other person can recover also from A. The instrument is valid, then, whether it is negotiable by the law merchant or not. The question as to whether or not it is negotiable by the law merchant becomes important when there are some equities which attach to the instrument, and then, if it is not negotiable by the law merchant, the person takes it subject to those equities. It has certain luggage attached to it which the person who gets the instrument must also take. He must take the luggage with the instrument. Therefore, it is important to know whether or not an instrument is negotiable by the law merchant. Instruments which have this luggage attached to them are binding, but we are considering now whether these instruments are negotiable by the law merchant for other reasons. In general, it may be here stated that there are certain essentials which an instrument negotiable by the law merchant must have. The bill must contain an order, not merely a request. A orders you to do so and so. He does not merely request you to do it. A note must contain a promise. A promise is to do. The order or promise must be unconditional, absolutely for the payment of money alone. Thus an order for 50 bushels of wheat or corn is not sufficient because not payable in money. There must be a payment in money and nothing else attached to it. The amount of money must be certain, the time of payment must be a time certain to arrive, and the instrument must be specific as to all its parties. In a promissory note it must be specific as to all its parties, that is, it must be specific as to the maker and the payee. In a bill of exchange the drawee and payee must be specific. Now, the question, whether an instrument has all these requisites which are required by the law merchant in order to be negotiable, becomes important when the instrument is in the hands of a bona fide purchaser for value. A person who gets a note with equities attached to it, and gives value for it, gets that instrument free from all those equities if it is negotiable by the law merchant. For instance, suppose a note has been obtained from A by fraud. He thinks he has been signing a receipt when in fact he was signing a negotiable promissory note, and he has been negligent in signing. It gets into the hands of X, and X transfers it to Y. Y can recover against A. That equity does not run against a bona fide holder for value. Suppose it has some of these essentials lacking in order to make it negotiable. In that case X, Y, or the person who holds the instrument for value, would take it subject to the equity that the note was obtained from A by fraud. If it was not negotiable by the law merchant, A would have a right to take advantage of that equity. There are some things which even a bona fide holder for value without notice cannot maintain suit against. Suppose someone forges A.'s name to a note. Now, the good reason of the law merchant and merchants generally would hold that should not be held as valid against A, even in the hands of a bona fide purchaser for value without notice. A is not a party to it, and we shall find out later that is a real defense, and any person holding that instrument and trying to recover against A would have the right to set up against him that it was a forgery. even though it was negotiable by the law merchant and even though the person holding it is a holder for value without notice. Thus we see there is one fact and principle that we must bear in mind all the time, and that is, if a person makes an agreement or contract of any nature, and it is such a contract as would be binding in the law of contracts, then that contract is binding as between those parties. So, if a person makes a contract or a written instrument of any nature, whether or not that instrument is negotiable by the law merchant, he is bound if he would be bound by the law of contracts. If one attempts to make a promissory note or a bill of exchange but does not do it and makes some other paper, he is bound just the same. We must consider the difference. The law of contracts, we might say, controls always as between the immediate parties. The law of bills and notes becomes important when we consider the paper in the hands of an innocent holder for value. Section 21. Circulation when parties not immediate. As between the immediate parties. For example, the drawer and payee on a promissory note, circulation has not begun. But when it circulates in other hands, then it partakes of the nature of money and will circulate just as money does, providing it is negotiable by the law merchant. Suppose X promises to pay A $50 and to deliver him 50 bushels of wheat. Now, in the absence of any fraud or anything of that nature, that is absolutely binding as between them, and B can recover from A $50 and 50 bushels of wheat. Now, suppose that is assigned by B to C and by C to D. Now, that is a case where there is a valid contract. Any party to the instrument can proceed upon it and can recover. Now, suppose this instrument has been procured by fraud, that A believes he is making a receipt for 50 bushels of wheat to B and, as a matter of fact, he promises to pay him $50 and deliver him 50 bushels of wheat, but he is negligent and careless and as a result it turns out to be some other instrument. Well, of course, between A and B, B could not recover, but suppose B gets it and endorses it to C and C to D. Can D recover upon that instrument? Number. That is an instrument that would be non-negotiable by the law merchant and D could not recover on it. There were certain equities that went with it, and A can set the equities up against anyone who gets that instrument. So, when it gets in the hands of anybody else, A has a right to set up that defense. Now, suppose it is negotiable by the law merchant. The promise is to pay $50 alone, but suppose the instrument has been procured by fraud from A by B instead of being a receipt. It is a promissory note and A thinks he is signing a receipt, and the circumstances are like the others. In that case B could not recover against A, although it has all the requisites of a negotiable instrument. As between the immediate parties the ordinary law of contracts would apply and the fraud could be set up. But let us suppose that it is endorsed by B to C and by C to D. D has no notice of any equity and gives full value for it, and he endeavors to recover against A. A cannot set up fraud as a defense because it is an instrument negotiable by the law merchant and in the hands of a bona fide holder for value without notice. A cannot set up that defense. Now, if D knew that had been procured by fraud he could not collect. If a person gets a negotiable instrument and he has given value and has no notice of wrongdoing, good common sense would say that he could recover just like he had gotten a $10 bill. That is the general doctrine underlying the law of negotiable instruments.